Hello and welcome to part 3 of my 5-part series of Family Law Introduction to the Basics. Today we're looking at children's issues. My name is Gail Lee and I am a solicitor at McHugh Lawyers in Chatswood, Sydney. Now in part 3 we will be looking at the meaning of the best approach method, parenting rights, parenting agreements, the court's focus and the issue of child support. Now, the best approach method is basically a child-centered approach. So before we begin though, it is worth touching on what the research tells us. Firstly, conflict is damaging. In extreme cases, it has been shown that high degrees of conflict can even cause brain damage. So conflict is toxic to children's development and their social well-being. If you are someone who finds it a struggle to keep their cool when dealing with their former spouse, don't think you are unique. My experience is that the difference between someone with the capacity to not expose their kids to parental conflict and someone who lacks that capacity is usually dependent on that person's degree of insight, maturity, and, to be brutal, intelligence. Your offspring will no doubt have questions. If you are struggling to know what to say or even with your own emotions, seek counselling. Don't be ashamed to ask for help. Now, the good news though is that children have a tendency to bounce back from these situations, provided that the conflict is not prolonged, the relationship that they have with their loved ones are both supported and encouraged, and their parents are able to work cooperatively for the most part. Now, no one expects childhood to be all lollipops and rainbows, but nor should it be a war zone. So use your common sense. So ask yourself whether you fit the criteria of a child-centered parent. Now, a child-centered parent does not make the child make their adult decisions. They'll take a child's view into account, but will be honest with themselves as to how much that view may be influenced by the parent's own prejudice. They can put their child's best interest before their own. They will not use their child as a way to manipulate the other parent. They're willing to change their own lifestyle if it means that they'll be able to continue a relationship with their kid or be able to help the other parent to be able to do so. They'll be open to the views of the other parent and not take or adopt a position simply out of spite or to punish the other parent. They'll not make the child have to choose between their parents. They will not denigrate the other parent, at least not in front of their child. Will not leave it for the child to negotiate arrangements as to when they'll spend time or whether or not they want to go. They actually understand what it means to act in the best interest of a child, and they will find other ways to deal with disputes that arise. So for example, through participating in counselling or family dispute resolution. They take the time to explain to their kids, what is going on and why, and reassure them. So again, do you fit the criteria of what a child-centered parent is? And look, I'm a parent as well, so I know we're all guilty at certain times of not perhaps thinking things through as well as we could have. But look, just take a moment to look at this slide, pause it, and just really bring it in as far as, is this something that you are doing at the moment? Because if it's not, then stop it and change your behaviour. If we move on, so parenting rights and the law. All right, so parenting rights and the law. Firstly, look, the earlier you understand that there are no explicit rights for parents or any other relative in the Family Law Act, the better. The legislative focus is on a bunch of primary principles and objectives, and you'll find these in Part 7, Section 60B of the Family Law Act. The principles underlying the objects of the Act are found in subsection 60B2. You should keep these in mind because if your matter ends up before the court is going to look at whether your behaviour has been in keeping with these principles. And we'll come back again to this a little bit later in this presentation. So parenting agreements, what are they? Okay, believe it or not, most parents who separate are actually able to decide between themselves the parenting arrangements without taking the matter to court. After all, parents are usually in the best position to know what will work and what won't. And fortunately, in the majority of cases, the majority of cases still have at least enough common sense to see the advantages of working together in raising the offspring cooperatively. Obviously, when I say this, I'm referring to family environments that are not subject to issues of family violence, alcohol or drug abuse. Look, where such issues do exist, the focus is one of safety. This is not to say, though, that without some help and assistance of professionals who are experienced in dealing in matters of that nature, that parenting plans cannot be negotiated. If this is something that affects you, though, I would encourage you to seek professional help and advice first. Moving on, though, where parents are able to come to some agreement, they can either keep it as an informal agreement, or they can put it in writing in the form of a parenting plan, or make an application to the court for consent orders. Now, informal agreements are simply that. They're informal. So the parents, they make their own arrangements about the care of the kids, and they do not feel the need to put it in writing. And that's fine. If you've got a partner or ex-partner, I should say, where that works, then there's nothing wrong with that. All right, so let's look at parenting plans now. So a parenting plan is basically, it's a written agreement between the parents of a child that outlines the parenting arrangements between them. So, for example, who the child is to live with, how much time they will spend with the other parent, method of communication, how often. They can also cover child support to be paid and other issues, such as what to do if there's a dispute, specific aspects of parental responsibility, like, if one parent will be responsible more for the educational side and the other parent more responsible for the health decisions, that's okay, and what must be done to change the parenting plan. So solicitors who deal with family law can help with the drafting of the parenting plan, but another very useful, inexpensive avenue to look at is through the assistance of family relationship centres. Now, some important points to remember is that they're not enforceable, unlike application for consent orders, so I'll come back to that a little bit later. But even though they're not enforceable, so you can't go rushing off to the court and say, hey, we've got parenting orders and now I want an order because they're not complying. It doesn't work that way. But they actually can override existing orders that were made after the 1st of July 2006, provided that those previous orders were not subject to a court order that says otherwise. So what would basically happen is that the parenting plan would be used by the parties to as evidence if a dispute arises, basically to show what the status quo was before the matter went to court. Now, provided it is properly drafted, government agencies can also, such as Centrelink and child support agencies, will recognise a parenting plan as evidence of care arrangements. So with respect to child support, however, there are special rules that need to be complied with to make it enforceable. Now, consent orders. So consent orders, they're a type of parenting order which is approved by the court. So this is where it's different to the parenting plan, which we were just talking about. So if you are drafting consent orders in favour of a non-relative, though, you may be required to attend a conference with a family consultant to discuss the proposed orders first, unless the court doesn't think this is necessary. Now, consent orders, they come about one of two ways. So, if there are already proceedings on foot, then the orders would be signed and handed up during a court attendance or filed online by your solicitors, or if you weren't had legal representation, by yourself, and after they've been signed by the other party. Now, if nothing has been started in court yet, though, then you would file what is called an application for consent orders. So to find those orders, though, you would actually just go to the Commonwealth Courts portal and you'd be able to do that. Now, a tip. So if you have a local court that has a family law list, you can actually file your application for consent orders there instead. But before you do that, consider the implications of Section 96 of the Family Law Act, because it leaves it open for a party to the orders to appeal the orders. So even though they've been made by consent, as just a matter of right, if a party can actually appeal the orders. So if you perhaps are dealing with a person who has a tendency to change their minds on a regular basis, then don't go down this avenue. File your orders electronically through the Commonwealth portal, or go to the family court and hand them up there. Okay? Okay, so let's look at how the court approaches dealing with parenting orders. Now, when a court is making parenting orders, the Family Law Act requires the court to regard the best interest of the child as the most important consideration. So this is the paramount consideration. So whether you are making parenting plans or seeking interim parenting orders, or those consent orders, your application for consent orders, you need to be mindful as to how the court is going to assess what you put before them. So it begins by looking at the objects and principles, which we touched on earlier. So that was those Section 60B of the Family Law Act. So this is things like that both parents have a meaningful involvement. There's a protecting of the child from physical and psychological harm or exposure to abuse, neglect, family violence. That there's adequate and proper parenting arrangements that are in place for the children to be able to reach their full potential. So those are the things that you look at, and you can go back to the Act to remind yourself of what those objects and principles are. Now, they then go to what we call, there is a presumption of equal shared parental responsibility. Now, that does not mean that it is equal shared time. We'll get to that a little bit later. This is a presumption of equal shared parental responsibility. Now, when they're looking at this question and whether or not it applies, they're looking at things like, are there reasonable grounds for a finding that there is family violence? Or does the court consider that it's inappropriate to apply the presumption at this stage because it's involving interim proceedings? So these are the various things that they will look at, or perhaps that what's been put before them is simply they don't think is in the best interest of the child. Now, if the answer to any of those questions is yes, either the presumption will not apply at all, okay, or it has been rebutted. If the answer to those questions is no, then the presumption does actually apply. Now, if the answer to those questions was yes, this court must still have regard to the best interest of the child and look at what type of orders should be made in that instance. But moving on, if the presumption for equal shared parental responsibility box has been ticked, okay, then the presumption applies. All right, so let's say that the presumption does apply. So the next step is that the court will look at whether or not equal time can be given to the parents. So in order to look at that, they'll say, look, is it in the child's best interest and is it reasonably practical? So it's both of those things. If the answer to that question is yes, great, then the court must consider making an order for equal time. Remember, they just have to consider it. They don't have to make it. If the answer to that question is no, the court must consider substantial and significant time. And the best, and whether or not, again, whether it's in the best interest of the children and whether it's reasonably practical. So substantial and significant time includes both days that falls on weekends, holidays, weekdays, and allows the parents to be involved in the child's daily routine and occasions, special events. Reasonably practical simply means that factors are taken into account. For example, how far the parents live from each other, the parents' capacity to carry out the arrangements, whether the parents are capable to communicate with each other. So if you are in a lot of conflict with your ex, then the court will just go, look, it's just not practical for you guys to be constantly seeing each other if you can't communicate appropriately. So this is again where your behavior needs to be, you have to be mindful of your behavior. Now, if the answer is yes to the question, so let's say the court has said, look, substantial and significant time would be appropriate, then they will make an order for substantial and significant time. If the answer to that question is no, they need to make orders still having regards to what's in the best interest of the child. So what does that mean? How do you actually determine what's the best interest of the child? Well, the primary considerations is that the court wants to be able to encourage the children to have a meaningful relationship with both parents, but at the same time they need to be able to protect the child or children from physical or psychological harm or exposure to abuse, neglect or family violence. And you also need to be mindful that Section 60CC2, so the primary considerations, will outrank Section 60CC2 A, okay? So additional considerations, this is where the child's view will come into play, what kind of relationship they have with their parent, the efforts a parent has gone to maintain a relationship, or what a parent has done to inhibit, interfere with the other parent's ability to have that relationship with the child. What's the likely impact on the child's emotional abilities? Look, some kids, struggle to handle change, and if they've just haven't had much contact with one parent, that will be taken into context. And this is where you have really sad cases, because if you have a parent who has, acted in a manner which has inhibited that child from having a relationship with the other parent, and the child is now at an age or has a developmental issue, so it really makes it hard for the court, even if they want to be able to grant access orders. I shouldn't say access orders, but significant or substantial time with the other parent. That relationship's been sabotaged. Now, something that you need to also understand is that if you have engaged a solicitor, or perhaps you've had one before, but they discontinued or you terminated their retainer because they weren't agreeing with you with respect to the parenting orders you were seeking, or even, or maybe because you were habitual non-compliance with the orders despite your solicitor advising you that your behaviour is not appropriate, you need to understand this. When it comes to children in proceedings, the solicitor has a duty to act in that child's best interest, and that duty comes before their duty to that of their client. So a solicitor cannot hide unfavourable expert reports, nor can they put forward evidence that they know to be false and misleading. And if they are dealing with a delinquent client, they actually have a right and even a responsibility of ceasing to act. So look, the reality is that most solicitors, they try to do the right thing by their clients, but family law is highly emotive. People will say and do things that ordinarily they wouldn't do, simply because something they value or feel entitled to is threatened. But being successful in a family law case, if you can call it that, doesn't come from repeatedly saying best interest of the child over and over again, or dredging up every bad thing your ex ever did. Your case depends on your character and the factual details you provide to the court. If you have engaged a solicitor, remember, trust goes both ways. Your solicitor's main objective should be to try and help you resolve the dispute as quickly and effectively as possible. And you need to be willing to listen to the advice that they give you, especially where that advice involves the child's best interest, because that is what's paramount also to the solicitor's consideration in providing you with legal services. All right, so let's look at topic number 5 in this presentation. So we're moving on to child support. Now, child support is actually looked after by the Department of Human Services, so it's more administrative in nature than court-based. An applicant for child support must be a parent or an eligible carer. The key requirement is that the applicant must not be living on a genuine domestic basis with the payer. So even though you're under the same, you may even still be under the same roof, but you're not living in a relationship together. The payer must be a parent. Now, there are some useful resources out there for you. I find that two of the most useful ones is the calculator and the child support guide, which is, as you can see on the website, just go to those links. An important tip, though, is that although it's administrative in nature, it's not isolated in the context of a family law dispute. So because it's closely interconnected to a parenting and property matters. So, for example, a parent who fails to help to financially support their child will find it difficult to convince a court that they are acting in the best interest of the child. So the formula for calculating child support, all right, I've really tried to keep this basic, but there are lots of little factors that come into play along the way. But just as a general formula, we'll go by this. So the main components of the formula are that the costs of raising the children, both parents' income, deduction of the parenting self-support amount, and the level of care each parent provides. So we'll explain this a little bit further. So there are 8 steps. Now, the first step is that you've got to work out what each parent's taxable income is. So this includes any net rental loss or fringe benefits, and then you take away the parenting self-support amount. Now, the other thing I should say is that if there are other dependent children or more than one, child support assessment that's already been done, a further deduction is made at this step. Now, so the next step after that is you work out the combined child support income. I just see a typo there. I'll have to fix that up later on. So you basically combine what the taxable income was of both parents, and you get that total figure. So step 3, you then work out what your individual income percentage is. So, for example, if mum's child support income was $20,000 and dad's is $60,000, then the combined child support income, step 2, is $80,000. Mum's income percentage is 25% of that $80,000, whilst dad's is 75%. All right, so step 4, this is where you work out your care percentage. And that's based on the number of nights in a 365 calendar year that the child will live with each parent. So, for example, if there's only one child and they live with mum 292 nights a year and dad 73 nights, then mum's care percentage will be calculated to be 80%, while dad's is 20%. Step 5, you then work out your cost percentage. So this is taking, you go to the table in section 55C of the Child Support Assessment Act. You take that percentage that you calculated at step 4 and you see where it falls in that table. So in our previous example, it would mean that mum's cost percentage would be 76%, while dad's is 24%. The next step you go is then you work out your child support percentage. So this is where you go back to step 3. So that's to do with your income percentage, and you minus, you take that figure, that percentage, and you minus from it the care percentage. So, for example, at step 3, we calculated mum's income percentage to be 25% of the total income. And so we take that and we minus the 76% and we get minus 51% child support. Dad, we do the same thing. He was 75% for his income, and you take away then his care percentage, which is 24%, and again you roughly get about 51%. Now, if the figure is positive, so if the number is positive, you need to pay child support. If it's negative, that means you are entitled to receive child support. So the next step, step 7, is where you work out the cost of your child. And this is done using a table that you find in Schedule 1 of the Child Support Assessment Act. So again, use an example. If this couple, if their child was 12, if you actually went to the table and you looked up, they're 12, their combined income is $80,000, and we know that from before. Then the cost of their child is $11,777 plus 12 cents for each dollar over $73,606. And when you calculate that, it would come to an amount of $12,000.28. It's using the table, and it's very mathematical, as you can see. Now, step 8, you work out the child support amount. So we already know dad's going to be the liable parent because he was in the positive, whereas mum was in the negative. And so what we do is we take his 51% and we have to calculate that 51% of $12,000.28, and that comes to $6,120.14 per year. Okay, so that's how much dad would be calculated to pay for child support, or roughly $510 per month. Okay, so just some important points to remember when dealing with child support. There are many, but we'll just touch on these ones. There is an obligation to apply for child support if you are receiving Family Tax Benefit A. It's called Reasonable Maintenance Action. The reason for that is very simple. The government doesn't think the public has to financially support your child if you have another means of being able to receive some level of support. So the onus is on you to actually make an application. The other thing is that the formula is meant to be flexible, and I appreciate that it seemed very logistical beforehand, but it is meant to be flexible. So if you do not agree with the assessment, you can make an application to a Child Support Review Officer for a change of assessment, and there are 10 grounds for review which are found in the section 117 of the Child Support Assessment Act. Now, a couple of things just before we move on. Victims of family violence, you can obtain an exemption from the requirement to take reasonable maintenance action. The grounds include violence or fear of violence and harmful or disruptive effect on the payee or payer. Some examples of grounds for a departure order to be made include high childcare costs. So if you have a child with special needs and that obviously their cost is going to be more than what the schedule usually allows for, then that is a grounds for a departure order. High costs involved in a parent to take care of the child, income earning capacity, property and financial resources, all these things can come into play when you're dealing with an assessment. All right, so let's look at child support agreements. Now, these are private agreements that are made between the parents. So this is where it's different to a child support assessment, which is done by the government agency. Part 6 of the Child Support Assessment Act recognises two types. You have binding agreements and you have limited agreements. Section 80C and 80E of the Child Support Assessment Act set out the technical requirements for these agreements. Now, the key differences are these. Binding agreements, they can actually be for less than an assessed amount. They're more difficult to set aside unilaterally once they're made. You must have received independent legal advice, and that makes sense. Obviously, if you're signing a document which provides less child support than you otherwise would have been entitled to receive, or maybe more, or you're paying more, and you can't set these things aside very easily, it's important that you receive independent legal advice. And the child support assessment does not need to be in place. So you don't have to go through that pathway first that we were discussing before. Limited agreements. Now, limited agreements, it does require a child support assessment to already be in place. You do not require independent legal advice. They can be terminated after 3 years by either party, or if the amount payable under a child support assessment changes by more than 15%, but they cannot be less than the assessed amount. So these might be more useful for, let's say, you've got a child that's close to their becoming an adult. This might be something that you find more flexible for you. Well, look, that's the end of part 3 of my 5-part series. I hope again that you got something of value from it. Please feel free to contact me if you have any questions or any suggestions. Thank you.